Hello, everybody, and welcome to another KN Talks. I'm chatting today with my colleague from the KN corporate team, Glafkos, Tombolis. Glafkos is a real expert in the National Security and Investment Act, and we've had a couple of incidents recently where people haven't realised that this is something they really need to think about in the context of selling their business or potentially acquiring another business. There was a lot of talk about this a couple of years ago, but I think that people have kind of forgotten about it. And so we thought it would be useful to do a bit of a reminder for people. Glafkos, thanks very much for joining me on the podcast and agreeing to talk about the subject.
Thanks for having me, John.
Great. So the National Security Investment Act, just to remind everybody, what is it?
Yes, this is a really consequential piece of legislation that came into force just over 2 years ago at the beginning of 2022. What this act does is it basically requires, in certain circumstances, a buyer of usually a target company, but not necessarily just a target company, to obtain approval from the government if the target company poses, this is putting it very broadly, poses a national security risk. And if the buyer doesn't do that, then the transaction is deemed to be void, and there are quite severe criminal penalties that could be imposed on the buyer. In addition to fines as well. So it's a very, very serious piece of legislation. And it's in fact the UK's first standalone national security law. Lots of other countries have had national security or foreign direct investment type legislation for many years, including America, most of continental Europe, Australia and countries like that. So the UK was a bit of an outlier in the sense that it didn't have its own dedicated national security law, but now it does.
And what kind of companies does the national security law actually apply to? Because presumably it's not everybody.
That's right. I mean, the law is very, very broadly drafted. So it doesn't just apply to companies incorporated in the UK. It essentially applies to any form of company that's carrying on some kind of activity in the UK. That's just at a very broad level. So I think the jurisdictional basis for the Act applying is that there has to be some underlying activity in the UK. But the activity in the UK can be something as tenuous as making supplies into the UK. It doesn't necessarily mean having an established place of business. It's very, very broad, and therefore the triggers are very low.
And are there particular sectors which this is relevant to, where people should be having at the back of their mind they might have a problem?
Yes, that's right. There are 17 sectors specified in the legislation. And what the legislation says is if a buyer is making an acquisition or making an investment of more than 25% in an entity that carries on activity in any of these 17 sectors, then that triggers a requirement for a mandatory notification to be made. And the sectors, just to give an example of a few, artificial intelligence, nuclear, communications, data infrastructure, defense, military, dual use, advanced materials, just to give an example. So some of those are quite obviously relate to sensitive areas of the economy, but some don't. So for example, artificial intelligence is extremely broad, and there are so many businesses that use AI in one form or another. So that could potentially capture lots of acquisitions or lots of investment, which is why I think parties need to be really, really careful when they're evaluating a transaction, just to see whether the legislation might apply if the target is involved in some kind of technology which uses AI, for example, or develops AI.
That's really interesting. So a lot of tech businesses then who perhaps don't think they've necessarily got any defense or national security implications to what they're doing may still be caught by this and need to jump through the hoops to avoid those criminal consequences. And even worse, if you're a seller, having to give the money back because the transaction is void.
Yes, exactly.
Okay, and then so if somebody is in a transaction and thinks this might apply to them, what should they do?
So if really the onus is on the buyer, but obviously the seller or the sellers also have an interest in making sure that the relevant notifications are made because of the consequences that we've just discussed. Certainly on the buyer side, what you should be doing is undertaking an analysis with your lawyers as to whether you think the transaction is in scope. And in order to do that properly, you're going to need information from the target group about the target's activities, because you're going to need to understand exactly what it does, what its turnover is, where its markets are, in order to make an informed assessment and to enable the buyer to take proper advice from its lawyers as to whether the transaction falls within scope. So there's necessarily a cooperation between the buy side and the sell side at the outset of a transaction. If the buyer concludes that a notification needs to be made because the relevant triggers are met, then the buyer has to complete a fairly detailed notification form that gets submitted. And the way the legislation works is that the transaction cannot complete unless and until the Secretary of State has approved the transaction. So to try and complete the transaction would constitute a crime under the legislation. It's an absolute no-no. The issue for the buyer and the seller, though, is if they want to sign the transaction and complete later, then that inevitably raises a question of what the conditionality should be and what happens between signing and closing. When does the buyer have the right to walk away from the transaction? Is it when the Secretary of State comes back and says, we're not approving the transaction, but we want to impose some conditions, or wants to ask further questions? There'll be a point at which the buyer might want to cut its losses and walk away from the whole transaction. So that's going to require negotiation and careful drafting.
Excellent. And is there anything else that we should be letting viewers know about the NSIA for them to keep in mind at this point?
Well, yes, the other thing to mention is it's a kind of, even though the legislation was passed in an Act of Parliament, the specified sectors, the 17, are set out in a statutory instrument. So it's easier to amend those. And in fact, the government recently put out a call for evidence, which has had responses to, as to how to improve the legislation. So there may be further changes afoot in terms of how the specified sectors are going to be defined. And I should also mention as a final point that the Secretary of State is required under the legislation to put out guidance as to how he or she will exercise their discretion in terms of whether to call in a transaction on national security grounds. It's fairly detailed. It's called a Section 3 statement, and it was recently updated to reflect this call for evidence. And it gives you a reasonably good insight into the thought processes of the Secretary of State as to the kinds of things that would constitute a national security risk. Some of it is obvious. So if you have an overseas hostile state that's making an acquisition of a vision sensing or facial recognition business in the UK, that would clearly raise issues and is very likely to be blocked by the government. But there are sort of less obvious examples where the guidance gives you some, I think, useful information as to how the Secretary of State might exercise their discretion. But and again, this is not meant to sound self-serving for lawyers, but it's not really a substitute for taking legal advice, because if you look at these specified sectors and the statutory instruments which set out what they are, some of them are quite technically drafted, and so it will require expert guidance, I think, before a buyer can evaluate them properly.
Yeah, and the headline titles of those sectors are not always terribly enlightening. I recall having a slight panic when I first read that transport was going to be a regulated sector before I dug down into it a little bit and realised it didn't mean all transport. It meant
that's right.
Airports and ports.
Yes, yeah, that's right. And there are a few, like defence is an obvious one, but energy, transport. If you look at those, and communications, they could potentially capture huge swathes of the economy, and also a multitude of small companies. But that's not the way it works. They've got specific turnover and other thresholds within the legislation, so it's not really picking up smaller, relatively less consequential type businesses. It's geared at, I would say, systemically important type businesses within those sectors.
Yeah. It's all on nuance, which is why they need to come to you, Glafkos, and
absolutely,
proper guidance.
Indeed, yeah, I like that, John. That's absolutely right.
Great. Well, as I said, if you are thinking about selling your business, it is worth just having a look at what the headline titles of all those 17 sectors are. And if your gut feeling is, we might be caught by this, then reach out to Glafkos. He will be able to take a look, provide you with some advice, and advise you through the whole transaction, whether you're on the buy side or the sell side. So thanks very much again, Glafkos.
Thank you.
Everybody, please do keep an eye on our YouTube channel. We do try and release videos relatively regularly, and we hope to see you again soon. Goodbye.
Thank you. See you.